Welcome back to Immigration News and Views. My name is David Nachman. I'm one of the managing attorneys at the NPZ Law Group with offices located in Ridgewood, New Jersey, in Manhattan, and we also have an affiliated office in Canada, and we have an affiliated office in Mumbai, India. So today's segment, I'd like to talk to you a little bit about marriage cases. And what is a marriage case and how does it work? And this is a question that we get very frequently from individuals who call our firm looking for advice about whether or not to marry their foreign national spouse in the United States and to do the filing here, or whether to go abroad, marry them in their home country, and then come back to the United States, do the filing, and send the visa back to them over there. Another option, of course, is that they can look into the possibility of doing a fiancé visa. The fiancé visa, this is of course before the individual is married. If the individuals have met in person within 2 years of the filing, the person can come to the United States, file a fiancé visa, send the fiancé visa over to the foreign national abroad, and they can enter the United States on a fiancé visa as long as they're going to be married within 90 days after entering the United States. Another way that it can be done, there's another visa called a K3 visa. The K3 visa is not exactly, it's not used often. However, what it does, it gives individuals the opportunity to be with their spouse on a non-immigrant visa in the United States, so they can enter on it's called the K visa. They can enter the United States, a K3 visa, and they can be with their spouse with work authorization. So the most salient of these methodologies is either filing here in the United States if your spouse is here, or to file the case abroad and have the visa sent abroad. So let's talk about those two. So first of all, if you have an individual a foreign national spouse who's entered the United States with status, and whether they're presently in status or not may not be incredibly relevant, because even if they are out of status, they can, as long as they've entered with inspection, which means that they've gone to the port of entry, they've been admitted and inspected by a Customs and Border Protection officer, they are able, even if they're out of status, to file an application for adjustment of status simultaneously with a petition for an alien, for a foreign national relative here in the United States. So that we call that a simultaneous filing of a marriage case. And that oftentimes is the easiest and fastest way to get a green card in the United States. Here in New Jersey, the processing time for a case like that is anything between 3 to 4 months. So from the time that we submit the filing, the package, a simultaneous filing, again, which is the petition for the foreign national relative, along with the application for adjustment of status, then what happens is that the processing time can be 3 to 4 months. What we do is we put together the paperwork, which entails, of course, those two documents that I mentioned before, along with an Affidavit of Support, the I-864, and several additional documents. We submit that to the lockbox up in Chicago. In Chicago, the lockbox gets forwarded to the National Visa Center, the National Benefits Center, and then the National Benefits Center forwards that package to the district office where the individuals get called for an interview. At that time, there'll be an interview where the individuals will be interviewed about the bona fides of their marital relationship. It's strongly recommended, of course, that you use competent legal counsel with regard to acquiring the information and documentation that's necessary to demonstrate the bona fides. Bona fides means good faith of the marriage, and that the people are, the individuals, the foreign national and the U.S. citizen, are actually married and are a couple. So there are a couple of ways in which that can be done, and we're going to save that for another video segment in the future to discuss with you what documents and what information can be utilized to demonstrate the bona fides of the marital relationship. Another way in which this case can be done is the U.S. citizen can go abroad and marry their foreign national spouse in any country, as long as it's a legally valid wedding. And then what they can do is come back to the United States and file a petition for a foreign national relative in the United States and request that the case be consular processed. What will happen is they will file the petition in the United States, and then the case will be forwarded to the NVC, not the NBC, but the National Visa Center. So actually the I-130 does go to the NBC, and it gets processed at the NBC first. Then it gets sent to the NVC, the National Visa Center, and then once the National Visa Center is able to make sure that the file is properly straightened out, it's sent to the U.S. consulate abroad, where the request is made for consular processing. At that time, the foreign national goes into the U.S. consulate abroad, and what they do is they process for the visa stamp, and they enter the United States as a green card holder. So those are the various ways in which a marriage case can be done. If you or any member of your family or your friends are looking for additional information about how to do a marriage case in the United States, or to send the visa abroad to your foreign national spouse, please let us know, and the attorneys at the NPC Law Group would be more than happy to assist you in any way that we can. Thank you very much.